Sorry, he is Savithri Parekh, and the topic for the day is dimensions of related party under Companies Act and CARO. And before we start the session, I am sharing my screen for the institute motto.
Forward, please.
येष सुप्तेषु जागृति येष सुप्तेषु जागृति कामं 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 कामंशो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्रं तद्ब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्द्वैता 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 एतद्द्वैता.
Thank you. This topic which we had chosen today is very, very important and is required in our day-to-day practice. So we thought that members should have the experience on this topic and they can raise their required queries also after the session. Last 15-20 minutes we have kept for this. Now I request our past convener and core group member, CA Chintan Saji, to formally introduce today's speaker, Savithri Parekh Madam. Over to you, Chintanji.
Thank you, convener sir. And it's my pleasure to have this opportunity of introducing renowned speaker who has been a very regular speaker at our study circle on the physical platform. And she just mentioned a few minutes ago that she's missing the physical platform. But anyways, we have to live with the times. So ma'am, we welcome you. And I just will do a formal introduction of ma'am, which is definitely all of our Javinagar members know her very well. So she's over 25 years of experience in the corporate field, and she's a company secretary at Reliance Industries Limited at present. She has worked in a variety of sectors, including manufacturing, outsourcing services, private equity, media, pharmaceuticals, textiles, and chemicals. She has authored many books on the corporate laws and is a specialist editor of A. Ramaiah, which is like, the Bible for the Companies Act. And also she is a general editor of MC Bhandari Guide to Company Law Procedures. And also she has authored a book on listing regulations published by LexNexis. She is at present the chairperson of the Corporate Governance Committee of Bombay Chambers of Commerce and Industry. And she has been a guest faculty at IIM Calcutta for more than 10 years. And she's a regular speaker at various programs organized by ICSI, ICI, Chambers of Commerce, and definitely our study circle also. She has been awarded many awards from the Foreign Commonwealth Office and gained exposure in the European law. She had interned with Richard Butler LLP, a law firm in UK, and gained hands-on experience in handling notifications under the UK Competition Act also. So with these words, may I request Savithri ma'am to please continue with the presentation. Thank you.
Thank you very much, Mr. Chintan, and thank you, Mr. Krishna Kumar, for this wonderful invitation. And as I mentioned a little while ago, I really look forward to this meeting of the JB Nagar Study Circle because personally, I find it very enriching interactions with the members who are very dedicated and, on a Sunday morning, spending time learning more about the law. It's really wonderful. And thank you very much for inviting me to address this session today morning. I look forward to a very interactive session. And, when I was asked about the topic, I felt one of the topics which has been there right from 2014, but every time you peel a layer, it's like peeling an onion. There is one more layer which is yet to be peeled. And that's exactly the reason why I chose this particular topic. And more importantly, because CARO has come into effect now, CARO 2020, and this financial year onwards, your report will also include CARO 2020 related disclosure, which is just a simple one-liner. But what are the dimensions of this one line in your report is what I wanted to address in this particular session. Talking of related party transactions, it's been there, as I mentioned a little while ago, right from 2014 onwards in Companies Act 2013. So what's so new about it? What is new about the compliance, or for that matter, even about the reporting? What's important is the importance which has been given and the emphasis which has been laid on compliance with respect to related party transactions has gone into another dimension also because of the recent incidents that we've seen in corporate India, and because of which even the statutory auditors are now required to comment in their CARO report. As all of you are aware, it will be like taking coal to Newcastle if I were to talk about CARO, but I certainly would talk about Para 3, Subpara 13, which very clearly imposes a responsibility on the statutory auditor to specifically mention as to whether all transactions with related parties are in compliance with Section 177 and 188 where applicable, and details have been disclosed in the financial statements as per accounting standards. Now, this is one provision of law where you have accounting standard disclosure, which is what Companies Act Schedule 3 requires you to do, and also read with Section 129. You now have a CARO confirmation from the statutory auditors, and of course, if he is not satisfied, he would have to either qualify or give adverse remarks. And of course, even with respect to the subsidiary companies, this becomes relevant and important. As you all are also aware, with respect to CARO report, it has been specifically mentioned in CARO itself that it's going to be on the standalone financial statements of the company. However, Para 3, Subpara 21 very clearly states that if there is any qualification or adverse remark with respect to any of the paras in the auditor's report, in the auditor's CARO report of any of the companies which have been consolidated in the CFS, then the auditor is required to comment on the same also. Is basically required to mention and draw out this particular non-compliance. Just to sum it up, the emphasis on related party transactions of the company as well as of the subsidiaries, therefore, would get placed before the shareholders in the form of the auditor's confirmation or otherwise in his CARO report. And that's that's actually going to be the ultimate level of assurance. In fact, if you ask me, I would say that just reading the CARO report is going to be the first level of due diligence for any company actually, because the CARO has been made so exhaustive. CARO read with Schedule 3 is going to give all the details that are actually required to be disclosed by a company. Coming back to the CARO disclosure, where it says three things. One, is the company in compliance with 177? Two, in case Section 188 is applicable, is the company in compliance with 188 also with respect to all the related party transactions? And the third, whether the company has made disclosures in its financial statements with respect to related party transactions. Of course, in case of companies which have adopted Ind AS, most of the companies have, it will be Ind AS 24, and disclosures under Ind AS 24 will therefore need to be seen as to whether they have been properly disclosed or not while giving a confirmation in the CARO report by the statutory auditors. Let us now try to peel this and see as to what exactly would the statutory auditors see to be able to confirm that the company is in compliance. Going by provisions of Companies Act requires compliance at two levels. One, at the level of the audit committee, and second, at the level of the board, in case it's one which requires board's approval, which is the reason, if applicable, has been put in. And of course, there are certain transactions which will go to the shareholders also, even going by the construct of Companies Act 2013. I'm not going to touch upon LODR requirements right now, but if there are any questions, I'll be happy to take that on board also. Coming back to disclosure, coming back to the provision of section 177, once again, 177.44 is a single line statement where it says that the audit committee has to approve all transactions with related parties. Now, 177 and the wordings of 188, there is a subtle difference in the sense that 177.44 says all transactions with related parties. 188 says related party transactions, and there are certain specific types of transactions which have been covered in section 188.1. Those are the only types of transactions which will fall under 188, and in case it exceeds the threshold, it needs to go for shareholders' approval. But if it does not exceed the threshold, the board is competent to approve the nature of transactions which are given in 188. Let's move back to 177. But before that, in terms of assurance, how does one take this process forward? First of all, one needs to see whether the transaction is with a related party at all or not. Section 2, subsection 76 defines as to who the related parties are. It is a definition of related parties, and it also, section 2, subsection 77, gives the definition of relative. Now, based on the definition of related party and relative, one would see as to whether the transaction of the company is with a related party. Let's say, for example, a director or his relative, or the KMP or KMP's relative, or if it is a private company where the director is a director or a member, or you have a subsidiary, associate company, holding company, all these would be treated as related parties. And if it's a transaction between the company and a related party, then automatically 177 will come into play. 177 comes into play only if the company has an audit committee. What if the company does not have an audit committee? You don't need 177 compliance at all. Then in that case, it's only a compliance under 188, which will need to be seen. And of course, 189, which is the one with respect to registers, which is a statutory compliance. However, for the purpose of CARO, that register is not directly called for in question, but a statutory auditor must also check the entries made in the register of contracts. Coming back to 177, in case the company has an audit committee, in case the company is required to constitute an audit committee, which is applicable only to listed companies or public companies which meet the threshold, then such a company needs to ensure that all transactions with related parties are necessarily brought before the audit committee, and the audit committee has to approve it. Now, Section 177 is quite an elaborate provision, and also there have been amendments which I will cover in a bit. The point here is under 177.44, the simple sentence is all transactions with related parties. Now, when you're referring to transactions with related parties, it could be transactions which are covered under 188. It may be transactions which are not covered under 188. Both these classes of transactions will all get covered in 177. Now, let's look at a couple of examples. It may be a transaction of granting loan to a subsidiary company. It will not fall under 188, but will certainly fall under 177, requiring audit committee's approval. Now, when the audit committee approves, what is the basis on which it would approve? The audit committee is obviously going to be seeing as to whether it's in the interest of the company. Of course, when you're talking of loans, you also have another provision of CARO, which says whether the loans granted by the company are in the interest of the company or not. And coming back to Schedule 3 disclosures, loans granted by the company, whether by way of non-current or by way of current, will also require specific disclosure as to whether the loans have been granted to related parties or to others. And this distinction in any case is going to be there, which once again is in the context of loans, but related parties. So when you're referring to 177 disclosure, it is actually disclosure with respect to Ind AS 24, although there are other provisions under Schedule 3 which also require disclosure of relationship. For example, even with respect to companies which have got struck off, which is a new provision in Schedule 3 which has been introduced and which will be effective this financial year, that is 21-22 onwards. You're required to give the relationship. I mean, if there is a company which has been struck off, what is the relationship of the company with this company which has been struck off? Now, this relationship may be as a subsidiary, as an associate or otherwise, that is the relationship which will be brought in over here. And so therefore, in terms of disclosure, there are the scope has widened considerably, and more importantly, with respect to CARO, most important provision is an assurance from the auditor also. So if you look at the construct of Companies Act, it has approval by the audit committee, and as I said, approval by the board wherever applicable, approval by the shareholders wherever applicable, confirmation by the statutory auditors, and of course, confirmation by the secretarial auditors. This actually shows as to how important this particular provision is. And as you all are aware, in case of listed companies, there's a half-yearly disclosure which is also required to be made. So actually the pool of information which a statutory auditor will be checking is considerable, and it is based on this. Now let's try to peel the different layers of section 177 compliance. Now, under 177, the transactions which are required to be approved by the audit committee, the audit committee may grant an omnibus approval. Now, when would you grant an omnibus approval? On what basis would the audit committee grant an omnibus approval has been enshrined in the statute. Now, if the transactions are of a repetitive nature, then the audit committee will be justified in granting an omnibus approval. A one-off transaction will always have a specific approval which would be granted. Now, if it's a specific transaction which falls under 188, now when the term used is falls under 188, it will mean that it is of an activity which is covered under section 188 subsection 1, then you cannot pass a circular resolution. It has to be approved only at a meeting of the board of the audit committee. However, if it is a transaction which is not falling under 188, then the audit committee, in exercise of powers under section 177 of the Companies Act, can pass a circular resolution and approve the omnibus resolution or omnibus authority also, omnibus approval also. There is a procedure for review of, there is a mandatory requirement of the audit committee reviewing the transactions which have been executed by the company pursuant to the omnibus approval granted. Under Companies Act, there is no frequency which is mentioned as to at what frequency the review should be made. However, in case of listed companies, in fact, now the provisions are also applicable to listed high value debt listed companies, that is high value debt listed company, debt listed entities is the term used in LODR. High value debt listed entities, which can be companies or other bodies corporate. Now, in case of high value debt listed entities, the compliance with respect to related party transactions will also get attracted, and therefore, in case of such listed entities, equity or high value debt listed, the review has to happen every quarter. But under Companies Act, there is no specific review period which has been mentioned. Now, so under 177, let's assume it's a repetitive nature of transaction. For example, if the company has been buying from, let's say, its holding company, then you can have an omnibus limit which has been granted for such purchases from the holding company. The omnibus limit will have the amount given as well as the terms on which it normally is approved is also to be mentioned. So you have the name of the party, terms and conditions on which the transaction is approved, the overall limit with which the audit committee is approving. And the audit committee will also have an overall limit. It has to have a related party transaction policy, the criteria on which RPT would be approved. And this criteria typically is approved by the board also. And based on that, the audit committee would be granting the omnibus approval from time to time. The omnibus approval has a validity period of not over 1 financial year. So which basically means the omnibus approval is taken for every financial year with respect to the same nature of transaction with the same kind of parties. And as I mentioned a little while ago, 177 is far more comprehensive. So all kinds of transactions with related parties will automatically fall under its fold, while under 188, it's only specific nature of transactions. So if it's a transaction where, let's assume the matter is placed before the audit committee and the audit committee does not approve the transaction, what happens thereafter? Does it mean that the company cannot execute the transaction at all? So this proviso was subsequently introduced in section 177, where it says that if the transaction is one which is of a nature which falls under 188, then if the audit committee does not approve it, if it is not of a nature falling under 188, sorry, and if the audit committee does not approve it, then the audit committee has to give its recommendations to the board for the board to approve. Basically, what is proposed to be done is, if it's a transaction which requires approval of the board, the law presumes even if the audit committee is not approved, it will anyways go to the board, and the board will have the authority to approve or to disapprove. But in case of a transaction which does not have to go to the board at all, in that case under 188, then in such a case, if the audit committee does not approve, then the audit committee gives its recommendations. Now, this recommendation, although has a positive overtone, here it basically means the comments of the audit committee will need to be given for the matter to be placed before the board, for the board to consider it. Let's consider a situation where the board considers a matter which has not been earlier approved by the audit committee. And let's assume the board approves it. It may be because there may be certain other facts which may have been considered by the board. The board ultimately consists of people from the audit committee as well as a larger set of directors who would also be there, on the board of the company, and the board in turn approves it. It's quite possible because there are additional facts which may have been considered, and the audit committee members may also have subsequently at the board approved the transaction. However, in the director's report, in the report of the board of directors, which is placed before the shareholders, any decision of the audit committee which has not been considered by the board will also be a fact which will have to be mentioned. So here in this case, how exactly does a company show that an audit committee, the audit committee had not approved, but the board had considered this? This fact will need to be mentioned. And this is also one of the important disclosures under Companies Act. However, as I mentioned, the auditors are only required to comment on accounting standard relating disclosure, which is basically with respect to disclosure in accounts. Of course, in case of listed companies, the term related party transaction includes transactions which are covered under Companies Act, plus also accounting standards, which basically means that in case of listed companies, the transactions falling under para 9B, which are not there in Companies Act, will also be treated as transactions with related parties requiring prior approval of the audit committee. In fact, in case of listed companies, from 1st of Jan 2022, it's only the independent directors who have to approve, independent directors on the audit committee who have to approve all related party transactions in case of listed companies. So actually you have the audit committee, and if there is any non-executive director who's not independent, then all other independent directors are the ones who have to approve, which basically means that you need to see whether you have had quorum with respect to that matter or not. Anyway, that was an aside. Coming back to 177 and 188, what happens if the audit committee has not approved and if the matter has not been placed and the transaction has been entered into with a related party? Then the company will have the right to seek indemnity from such a director of the company concerned. And of course, the right to ratify a transaction with a related party is covered in Companies Act. although the Companies Act does not very clearly say that you need to get prior approval, with respect to 188 also, the provision says that if within 3 months you have not ratified, which means the law presupposes that within a period of 3 months, you can ratify the transaction. While in case of listed companies, the law is very clear, Regulation 23 very clearly refers to prior approval by the audit committee. Now, in case of companies where the transaction is in the ordinary course of business and on arm's length basis, 188 very clearly grants an exemption. So it says that section 188, the requirement of taking board approval will not arise under section 188 subsection 1 if the transaction with the related party is in the ordinary course of business and on arm's length basis. Now, how exactly does one define ordinary course of business, and how does one determine whether it's on arm's length basis? Talking of arm's length basis, the term used is not arm's length price, but arm's length basis. Now, arm's length price, of course, you have the income tax provisions and the 6 methods, commonly known 6 methods, under which you would have, the most commonly used one is the cup method, where you would determine as to whether the price which is being charged in a transaction is comparable or not. Although markup method is also a very commonly used method where you do not have a common uncontrolled price with any other third party. But what is used, the term used in Companies Act is arm's length basis. Now, arm's length basis would cover something more than just the price. It will cover the entire set of terms and conditions which are bundled together along with the price. Because price in isolation may appear to be a sweetener, but at the same time, there may be other terms which may make it more favorable in favor of a related party. And that's the reason under Companies Act, the term used is arm's length basis. So therefore, all the terms and conditions will have to be taken together in a comprehensive manner to see whether it is on arm's length basis or not. But of course, everything else being equal, you would only look at price because that's the one which is easily quantified and seen. Coming back to ordinary course of business, the term ordinary course of business is not a defined term, and therefore there have been several requests to get this term specifically defined in the Act. I'm personally of the view that it's good that it is not defined because it's one which is very dynamic. You cannot say that, you cannot just straitjacket and say that these are transactions which are in the ordinary course of business, because business is dynamic. You cannot specifically rule out something saying this is not in the ordinary course of business. Like, for example, you may have a shipping company and which is engaged in transportation of cargo or otherwise. Now, will the shipping company require an aircraft? Now, depending on the nature of business, depending on what is essential for the business and the expansion which it has had, maybe it's operating in multiple jurisdictions, in which case it may be in the ordinary course of business, it may be necessary, and it may be leading to more business efficiencies and benefits. So, you cannot just put it in specific boxes and say that this is okay, this is not in the ordinary course of business. A commonly used way is to look at the memorandum and articles of association. If there is an activity which is very clearly covered in the memorandum, it will be said to be in the ordinary course of business, is a traditional way of looking at it. But what if it is ancillary to the main objects? Because that's the one where the scope gets far more comprehensive and where the scope gets expanded much more. And therefore, one needs to see whether the company needs to do something so as to be able to carry on its business in a more effective manner. So let's say, for example, subscribing to securities in the subsidiary, of course, would be considered as one where you are going to be supporting the subsidiary. The business of the subsidiary may be ancillary to the company, or it may even have diversified. So it may be an investment, which it looks to the long term for benefits. So therefore, those will all be considered as ordinary course of business. In the ordinary course, the parent company would be supporting the subsidiary. And in any case, there are specific provisions of law which permit. So if something is permitted in law, it will be considered to be okay to be doing it, and therefore in the ordinary course of business. So ordinary course of business is itself very, very vast, and that test also needs to be satisfied. And the second test is arm's length basis. So when the auditor, statutory auditor, confirms that all the transactions are in the ordinary course of business and on arm's length basis, and that the audit committee has approved the transactions under section 177, assuming there are no transactions where 188 is applicable, he would give a clean report on this particular point in his CARO report. Let's go to the next point of 188. As I said, ordinary course and arm's length basis, it will not fall under the board approval at all. But what are the nature of transactions? Buying and selling of goods, buying and selling of property, leasing of property, underwriting of shares and securities, appointment of a person, of a related party to an office or place of profit, are all transactions which will fall under 188. Now, under 188, let's assume it is for buying and selling of goods, and the company sells it to other parties also. You would then have the cup method, where you will be very easily able to satisfy that it is in the ordinary course and on arm's length basis. So the approval of board is not required. Now, while actually under 188, no approval is required, there is this register of contracts, which I mentioned a little while ago, where all the directors present at the meeting are required to sign the register of contracts, provided the entry in the register of contracts is required to be made. I mean, where you have Rule 16, which gives the specific provisions under which the entries in the register of contract will be required to be made. And based on that, the register of contracts, which is placed before the meeting, is signed by all the directors. Whether they are interested or not is irrelevant for signing of the register of contracts. Now, the signing also attributes knowledge to the directors. Although it may be a transaction which does not require board's approval, if it requires entry in the register of contracts, by signing the register of contracts, the director is attributed knowledge with respect to that particular transaction. Let's say, for example, a transaction may be in the ordinary course of business and an arm's length basis, and it may be with a, let's say, a subsidiary which has been promoted, which has common promoters. Then going by section 184, read with 188, read with 189, the entry in the register of contracts will become necessary. And this will, although not come before the board is aware of such transactions made with related parties. Of course, there are exceptions with respect to exemptions which are provided with respect to register of contracts. If the transaction in a year is less than 5 lakhs, it does not require any entry to be made in the register of contracts. The transaction, the threshold limits are given in Rule 15, and Rule 15.3 has the threshold limits. Typically, I mean, earlier we had a absolute limit as well as a percentage limit, but now it is only a percentage-based limit of 10%. Earlier it was 10% and 100 crores. Now it is only 10%. So if you have a transaction with a related party with let's say with respect to purchase or sale of goods, and let us assume for a second it is not in the ordinary course of business because you're granting some extra concession to this particular related party, and you require approval of your board, then it's such an event. The audit committee approval in any case is required, where the audit committee would have approved the transaction, saying that although it may not be in the ordinary course and on arm's length, giving the rationale, the audit committee has approved it and placed it before the board. When the board approves this, the board would take into account the unique benefits to the company and based on which it is approving it. Assuming it is of a value less than 10% of the turnover of the company, then the board has the power to approve it. If it exceeds 10%, then it requires shareholders' approval to this particular transaction. Now here, going by the provisions of section 188, there are, it may be with respect to property. Now, property may be tangible property, or it may be, capital asset, or it may be even intangible property. Let's say, for example, a trademark or a patent or the like. All these will get covered in purchase or sale of property. Leasing of property typically will be of immovable property only, and underwriting, those, of course, it's unique to issuance of capital and public issue of capital, or it could even be public issue of shares or even debentures. There is absolutely no bar in getting underwriting done if it is of debentures. Even in case of rights issue, you could still have underwriting, although it is not mandatory under ICDR regulations. Or office or place of profit. Office or place of profit is a very important and an interesting provision with respect to related party transactions. Now, in case of office or place of profit, I think there was one question. What was the question, please, if you want me to cover it? I'm not able to see it on my screen. Anyway, as I go along, I could just see it and I'll take it up. Okay, so office or place of profit, there's a distinction between a person who is a director of the company, or secondly, any other position. Say, for example, a director of a company is also holding another office, then one needs to see as to whether he's holding an office or place of profit or not. Now here, let's take a couple of examples. If let's say a director of the holding company is holding the position of a whole-time director in the subsidiary company, the explanation given under section 188 says that in case a person holds office as a director, then it will only amount to office or place of profit if he derives anything over and above what he is entitled to as a director. So therefore, the question here is he getting anything over and above what he is entitled to as a director? If he is not getting anything over and above what he is entitled to as a director, you don't have an issue, and it will not be treated as an office or place of profit, which basically means a related party can be appointed to the office of a director, and it will not amount to an office or place of profit unless he gets something over and above what he is entitled to get. There's a very interesting question that would arise with respect to a whole-time director drawing remuneration. As you all are aware, earlier we had limits under section 197. 197.1, the first proviso, stated that in case a person draws a remuneration in excess of 5% of the net profits for one director, or 10% for all of them put together, then you require a special resolution. Now let's take a simple example of a director who is drawing more than 5% of the net profits of the company. Then initially, at the time when you are appointing such a person, you would say that it can be treated as an office or place of profit, because up to 5% is considered to be the ordinary limit which he would have got ordinarily. But once the special resolution is passed, the related party provision is completely taken out of it, and subsequently it will be considered as an amount which he is entitled to. Post amendment to 197, what is interesting to note is this 11% overall remuneration limit is no longer there. You require a special resolution to pay anything over and above that also. Plus, for paying any amount, in fact, even in case of a company which does not have enough profits, Schedule 5 is applicable. And in Schedule 5, the first table earlier had, in Part 2, Section 2, the table had a limit of twice the amount given in the table, which is also no longer now applicable, because the company, by passing a special resolution, can pay any amount that it so deems fit. So what happens if the amount is in excess of 5%? I would personally hold a conservative view that in the first year, you should treat it as office or place of profit, and subsequent years, it will not be treated as office or place of profit. And of course, if you treat it as an office or place of profit, the related parties to that particular transaction will not be entitled to vote on that transaction. Companies Act, there's a circular which has been issued which very clearly states that only persons who are related parties to a transaction cannot vote, which means every other person who's a related party but is not related in that particular transaction can vote, which means under Companies Act, rightly so, the term related party is examined qua each transaction and not as a class of related parties generally, which also means that it is quite possible that a person may be a related party with respect to one transaction, but he may not be a related party with respect to another. Let me just give an example. Let's assume the same example of this managing director, Mr. A's relatives, that is Mr. A's spouse, parents, children, will be considered as related parties in the transaction of his appointment and drawing of remuneration in excess of 5% the first time when it comes up, because they are related parties to that particular transaction. But Mr. A's uncle, who's not a related party for this particular transaction, but who's also a director on the board of the company, will not be barred by this provision, and he can cast his vote. I repeat, Mr. A's uncle, who's a director on the board of the company, will be entitled to cast his vote, provided it's not a listed company. In case of listed companies, Regulation 23(4) is far more stringent. It says all related parties cannot vote, irrespective of whether they are concerned in that particular transaction or not, which actually means that in case of listed companies, related parties as a class are not permitted to vote, while under Companies Act, related parties to a transaction are not entitled to vote if the matter is placed before the shareholders. Of course, the threshold and the requirement under LODR is very different. You require shareholders' approval only if the transaction is a material related party transaction, where the threshold is 10% of the consolidated turnover of the entity concerned, while over here it's on the standalone basis. Under Rule 15(2), a related party at a board meeting will have to recuse himself or herself and move out of the room when the discussion on the transaction is being conducted by the board of directors of the company, which is basically to ensure that there is no undue influence of the person on the discussion, and the discussion happens in a free and fair manner. So broadly, with respect to related parties, if there is a director who is interested, then going by the exemption, if he gets anything over and above what he is entitled to get, only then it becomes a related party transaction, because it will be considered as an office or place of profit. Now, the term office or place of profit itself is an interesting term as to whether office or place of profit would presuppose that there should be an office which should be held. Now, office means that there is a position. It cannot just be with respect to a transaction. But that's not the way it is understood in Companies Act, because it says that if he gets anything over and above what he's entitled to. So the term office or place of profit, this place of profit is given a specific meaning under Section 188. What happens if a director has not just in the course of his work, but otherwise outside it, has certain other skills for which he is specifically engaged, and he is not performing it because of his position as a director? What happens then? Will that amount to office or place of profit? Let's take the case of a director who has, let's say, a patent, and he has given a worldwide right to that patent to several companies, and the company where he is subsequently appointed also wants to avail of the patent from him. Will this be considered as an office or place of profit? Is an interesting point, and let's examine section 197.4 in this context. 197.4 says if the director has certain specific qualifications which entitle him to be given some assignment over and above what he is supposed to do in the course of his position as a director, then that amount will not be considered as remuneration. As you are aware, the term remuneration under Companies Act has been given the same meaning as is given under Income Tax Act. And in fact, that itself throws open certain points, which I will cover in my session today. So here, this person, he has a patent, and the patent was not made while in the course of employment. And therefore, the patent is unique to him and it is his personal property. There is a worldwide, there are several companies who've been granted worldwide rights to this patent. So therefore, this particular right, which is uniquely his, is one which he is free to give it to any person he so desires. Let's assume the company that he is on the board of wants to avail of this patent because it is important to it. And the nomination and remuneration committee has to go into it and has to specifically approve that he has, the director has special skills which entitle him to give this particular right and patent, and therefore they approve it. Is it a related party? Answer is yes, it's a transaction with a related party. The audit committee also has to approve this transaction, and the audit committee will also see as to whether it's in the ordinary course and in the arm's length or on arm's length basis or not when it is granting the approval, depending on the policy of the company. And let's assume the director, since he's also on the board of this company, gives it at 50% discount. And it's definitely a sweet deal for the company to be going ahead at 50% discount where all others have paid much higher. This company is getting it at a much cheaper rate, and therefore the company is interested in doing it. Now, the third question that will arise is this a case of an office or place of profit? If the director gets anything over and above what he is entitled to get. Here, the director, by virtue of being a director, has got only his regular remuneration by way of sitting fees. Let's assume he's an independent director on the board of the company, or let's assume he is a non-executive director on the board of the company, and he's just got his sitting fees, which is definitely not any different from what others have got. In his capacity as a patent holder, he has got certain amount, and that amount has been certified to be in the ordinary course of business and on arm's length because the company is getting it at a much cheaper rate. Will this amount to an office or place of profit? I would say it will not amount to an office or place of profit. However, conservatively, companies sometimes, depending on the quantum of amount involved, do decide to take shareholders' approval. But technically speaking, since it is very clearly covered under 197.4, it will not amount to remuneration and it will not amount to office or place of profit also. Although it may exceed the threshold of 2.5 lakhs per month or 30 lakhs per annum limit, which has been given in 188. Talking of remuneration, the way it has been defined in Companies Act now, includes not just amounts which have been given to the person by way of under a contract of employment or otherwise. It will also include all perquisites, monetary value of any other benefits which have been granted to him. So therefore, in fact, last year there was this burning question on ESOPs. Of course, that's a question which is related to remuneration, which is also required to be certified by the auditors of the company. But at the same time, it's an important question to be considered because the year in which ESOP is exercised, it becomes remuneration of the person for the purpose of Income Tax Act. And for the purpose of Companies Act, what would be the point at which you would treat it as remuneration? Will it be at the time when the ESOP is exercised, or at a time when the ESOP is granted. So when you look at it as remuneration at the time when the ESOP is exercised, it is quite possible that the market rate of the shares may be quite high, and the net profit of the company may not really be sufficient in that particular year, in which case the limit of 5% may get crossed, and you will again need shareholders' approval if the approval earlier taken did not very clearly provide for the flexibility. And of course, if it was a special resolution, it's a different issue where you had provided an enabling provision. But what is important, suffice it to say that given these complexities, every year the resolution will need to be revisited to see whether it is revisited, as in to check whether it is comprehensive enough to cover these aspects or not. There was one question with respect to related parties on the point on, let me just try and see if I can see the question. Holding company issues support letter to associates and joint ventures. Is this covered under the ambit of section 188? Answer is 188 does not cover financial transactions, and therefore it is not covered in 188. Does it get covered in 177? My answer is it certainly gets covered in 177. And if you're referring to support letter, is it one which is carved out on Rule 10 of Chapter 12 rules? What you'll need to see is it in the nature of a guarantee, or is it just a support letter or a comfort letter as it is commonly called? Whether it's a comfort letter or otherwise, SEBI in its several circulars, including the one on commercial paper, has also referred to comfort letters, where I would say that any comfort letter which is given will also require audit committee's approval. Does it fall under 188? As I just mentioned a little while ago, it does not fall under 188. And 188 is a specific provision. You need to see whether it is specifically covered or not. If it is not covered, it does not fall under 188. Under SEBI LODR, with a support letter, and also under SEBI LODR. SEBI LODR, I would say that if it's a transaction with a related party, you are anyways taking approval under 177. And if there is no transfer of resources, because there is no transfer of resources happening under a support letter, so it actually, strictly speaking, does not fall under SEBI LODR. And if your support letter is an unconditional support on account of continuing losses and erosion of net worth. So here, when you're saying continuing support, what exactly is the support letter providing for? Does it say that you're going to be funding? Then the act of funding, because just saying that you will be supporting is one part of it. What is the action as against that you have done is what is important to be seen. And if your action is one which mandates approval of the audit committee under LODR, you need to take it. But in any case, under 177, if you're taking audit committee approval, then that itself automatically covers this. And in the resolution, you just need to cover the aspect of LODR also just by referring to it. And that should be good enough, because all that LODR requires you to do is to take audit committee approval and nothing more than that. Touch upon the SEBI updates in relation to related party transaction and auditors' responsibilities. You're referring to ones which would come into effect from 1st of April. Yes, I will certainly cover it. The holding company issues, that's what I covered. Yeah, okay. If the MD has offered patent IP to the company at a much cheaper rate than the market price, okay, fine. This is a very interesting question as to whether it is arm's length or not. And I would say, what exactly is the purpose of an arm's length test? It is the arm's length test has to be examined in the context of the company which is the beneficiary. So as a beneficiary, anything which is below will be considered as arm's length. It is not necessary that it should only be equal to. For example, if you refer to the FEMA provisions, where you are selling shares to a foreign party, it says the price should be not less than. But if you are buying, it says not more than. If you're buying from a foreign party, it says the price should be not more than what has been provided in the in the valuation report. So therefore, you just need to see whether the price for arm's length pricing, you need to see whether the price is in the interest of the company concerned or not. Just give me 1 second. My battery seems to be going low. Sorry. So therefore, I would say that there is absolutely no problem whatsoever if you're charging less. It's only if you're charging more that the problem would arise. Talking of the new changes, which are going to be coming into effect from the 1st of April 2022, changes made in LODR, it actually is going to expand the scope of related party transactions and the approval mechanism manifold. One is, currently related party transactions are considered from a standalone perspective. What I mean to say is, it is only relevant if the company is a party to a transaction with a related party. What is sought to be done from 1st of April under LODR, under Regulation 23, is that the related party, I mean, the changes have been made to definition of the term related party. And related party would mean the company or any of its related, any of its subsidiaries on one side. So instead of just the company as on a standalone basis, you're going to actually consider applicability of related party by taking the consolidated group of related parties on one side, that is the company and its subsidiaries, whether it is wholly owned subsidiaries or other subsidiaries, all of them on one side. The term subsidiary, as is defined in LODR, is the same meaning as is given in Companies Act. So subsidiary under Companies Act, as you know, it's basically based on majority of board of directors or more than 50% of the total voting power. So therefore, you would take all these entities on one side, and on the other side, you have related party of the company or related party of the subsidiary. So it's quite possible that you may have a transaction between a subsidiary and another subsidiary, but it will then require RPT approval. Of course, the proviso also says that there is a two-step provision which has been brought in Regulation 23, where it says that if it exceeds 10% of the consolidated turnover of the company, then it requires audit committee approval, even if the transaction is one where the company is not a party. That is, taking the example of the subsidiary dealing with another subsidiary for a transaction exceeding 10% of the consolidated turnover of the listed entity, then approval of the audit committee of the listed entity will be required. And come 1st of April 2023, it will be 10% of the turnover of the subsidiary concerned. So let us assume a newly incorporated subsidiary with a capital of 10 lakhs, turnover of 20 lakhs. You will actually have a threshold of 2 lakhs as the limit for that company's transaction with another company, irrespective of what the consolidated turnover is. But for 1 year, it's going to be the consolidated turnover of the listed entity, which will be taken as the threshold limit. And if it exceeds that, it needs to go to the audit committee. This is, of course, only if the listed entity is not a party. Let's say the listed entity is a party, even if the transaction value is minuscule, it will still require approval. So therefore, actually, it's a it's a much more wider construct. Corporate actions have been exempted provided they are corporate actions of the listed entity. Let me give you a simple example. Let us assume the subsidiary is going to raise funds, and the transaction value, the subsidiary wants, let's say, 2000 crores of capital to be infused. The listed entity will need to take approval of its shareholders because it exceeds the threshold of 1000 crores, which has been prescribed. So it is actually 10% of turnover of 1000 crores. Currently, for material related party transactions, you have a threshold of 10% of the consolidated turnover. That is going to be changed 10% of the consolidated turnover or 1000 crores, whichever is lower. So therefore, in case the threshold in terms of 10% or 1000 is exceeded, you require shareholders approval, and it has to be prior approval before you do the transaction. As I was mentioning, corporate action of the listed entity is exempted, but not of the subsidiaries. So let's assume one subsidiary dealing with another subsidiary, threshold getting exceeded. After 1st of April 2023, as I said, it's going to be 10% of that company's turnover. Then you would actually require for all those transactions to go to the shareholders of the parent company. The only exemption is if it is fully consolidated, you don't actually need to go because wholly owned subsidiaries are anyways exempted. Under 188 also, wholly owned subsidiaries are, transactions with wholly owned subsidiaries do not require approval under 188, provided they are consolidated in the financial statements and placed before the shareholders for their approval. This is an important provision because intermediate holding companies are not required to do consolidation, provided the conditions as are given in Rule 6 are satisfied. And in such cases, the intermediate holding companies, let's assume you have company A Limited, which is a holding company, ultimate holding company, B is an intermediate holding company, and C is the subsidiary of B. Let's assume all B and C are both wholly owned subsidiaries. B may not be consolidating and enjoying the exemption, and in which case, if there's a related party transaction between B and C, since B is not consolidating, it will need to take approval under section 188, although it has only one main shareholder, which is the ultimate holding company and other nominees. It will still need to place it before the shareholders of B. While in case of A, if it's a transaction of A with either B or C, since it is anyways consolidating, the ultimate holding company, of course, will have to consolidate, and therefore it will enjoy the exemption under 188. Even under LODR, a transaction with a wholly owned subsidiary is clearly exempted under Regulation 23. There was another question with respect to sections applicable to a private company under related party transaction. Now, that's an interesting question. Now, for the related party transaction, how does this related party transaction compliance start with? It starts with the disclosure received from the directors, because, with respect to holding company subsidiary, the company in any case is aware of, but relatives and the entities in which the directors have interest in terms of, the entities where the director, private company where a director is a director or a member or his relative is a member, those are provisions which are based purely on what the director discloses. In terms of private company, disclosure provisions are certainly applicable. Now, once disclosure provisions are applicable, if there is a transaction with a related party, then the director concerned can participate in the discussion at the board meeting after making his disclosure known, saying that he's a related party, but he will be entitled to participate in the discussion. Is 188 exempted for private companies? Answer is no. So therefore, in case of private companies, you will require approval at the shareholders meeting, and in case of private companies, the interested persons can still vote after making his disclosure known. Of course, under 188, there is a further provision which says that if 90% of the voting is by the same person or entity, then the restriction on voting will not apply. So if you have 90% being held by one person and remaining 10% by few others, you would be entitled to the exemption, which says that generally under 188, the persons who are related parties to a transaction, as I mentioned, cannot vote. But here they will be entitled to vote if 90% is held by the same group or same person. Case of a private NBFC, there are no borrowings and no outside loans to outside the group for some transactions which are not covered. There are a number of, no, I'm unable to understand this. In case of a private company, which is an NBFC, outside the group for some transactions which are not covered in 188, and also section 177 is not applicable. As an auditor, how to report transactions which are not at arm's length, and as management, is this needed to be reported in notes to accounts? So as management, yes, if there are transactions with related parties, you would be reporting it. And in CARO, the auditor will have to report that the transactions are not an arm's length. But actually, it's not just not an arm's length. If it is not an arm's length, 188 provides for approval by the board. But I'm unable to understand your question. If you can just clarify, or maybe you can just be unmuted for you to raise this question, I'll be able to answer this specifically. That was a question from Mr. Ram Prasad Soni. So anyways, while we are joint ventures by the company, yes, of course, in case of joint ventures, there is absolutely no distinction. Joint venture, see, when you're referring to joint venture, what is important is what is the definition of joint venture? Joint venture in Companies Act, or for that matter under FEMA, the term joint venture has a different meaning. But for the purpose of Companies Act, the term used is associate company. Section 2, subsection 6 defines the term associate company, and in the explanation, there's a reference to joint venture. And more importantly, it has borrowed the terms from the accounting standard in the sense that the term joint control is what is seen. Now, what's important is the holding more than 20%. If the holding is more than 20%, then for the purpose of Companies Act, it automatically becomes an associate. For the purpose of accounting standard, there is a further compliance which is required to be checked, which is of significant influence. So although you may be holding more than 20%, if you do not have significant influence, then even then the company will not be treated as an associate, and it will be shown as a joint venture only. So if it is less than 20%, it will not be an associate, and if it is not an associate, it will not be a related party. Yes, there was one question which I could not understand. If that question could just be repeated, please.
Madam, a small request. Most of our members are small and medium practitioners, and they in their kitty there may not be any listed company. So if some stress you will give on listed company, so that will be nice.
Okay, so cover listed companies?
No, listed company anyhow you are covering. So some stress on unlisted companies also.
Okay, certainly. Okay.
Yeah. Yeah.
Unlisted companies, as I was mentioning initially, whatever I covered was in the context of unlisted companies only. That is, the CARO provisions 177, 188 of Companies Act in isolation. Now, when you refer to 177, has the audit committee approved it? Now, if you're referring to unlisted companies, you would have to see whether the company has an audit committee at all or not. Let me look at it from a compliance perspective. Point number 1, have you received all the disclosures from the directors? Point number 2, what is the system that the company follows to identify and escalate related parties and transactions with related party? How many of these related parties have transactions with the companies. Once you've identified the entities which have had transactions, you would then see as to whether the company has an audit committee or not. If it has an audit committee, have all these transactions been approved by the audit committee? What is the procedure followed by the audit committee for approving? That is it a specific approval or is it an omnibus approval? If it's an omnibus approval, has it been reviewed by the audit committee? Whatever be the frequency, what has been the practice of the company in reviewing the omnibus approvals granted by the audit committee? And then you would also see, are these transactions falling under 188? If yes, have they been approved by the board? Were they within the board's threshold or did they require shareholders' approval also? If they required shareholders' approval, were the approval of the shareholders taken? And if the approval of shareholders was taken, did the related parties abstain from voting? This is the way you would look at the entire compliance, and that will be the checklist that you would be using to see whether the company has complied. For you to make a one single statement as per para 3 subpara 13 in your CARO report, saying that all transactions with related parties are in compliance with section 188, 177 and 188 to the extent applicable, and all the details have been disclosed duly by the company in the financial statements. So this would be the statement for you to do this. This is the way the checking would be done. And of course, your working papers will then have all the details of disclosures, the ledger statements, the nature of transaction, what has been the nature of transaction as to why you have done it. And based on the nature of transaction, you will also need to see whether it's a loan or an advance, because under Schedule 13, as per Schedule 3 also, the loans as well as advances to related parties specifically require a disclosure in the financial statements. Yeah, happy to take on questions, please. While I do know that it is almost 45 minutes instead of 15, I'm sure there are several questions, and if there are specific issues, I'll be more than happy to address them, especially in the context of small and medium scale.
If somebody would like to have the question, they can unmute themselves also.
Yeah, good afternoon, ma'am.
Yes, good afternoon.
Yeah, I asked the question regarding NBFC.
Yeah.
So some transactions like loan to the group companies, which is not covered in section 188 and is a private limited company, so section 177 is also not applicable.
Correct.
And the report is specifically with respect to section 177, 188. The transactions which are not at arm's length, so whether the auditor can report in the CARO or how to report it, or which standard or through which clause it can be reported.
Okay. So as I mentioned, in case of private companies, 188 is applicable. There is no exemption from section 188 under this June 5th, 2015 circular. So in case of private companies also, if it's a transaction which falls under 188, let's say it's a transaction of purchase of goods entered into by a private company with its related party, then you will need to ensure compliance of 188, and probably it's one which is in the ordinary course of business and on arm's length basis and therefore board approval, or probably it's not in the ordinary course of business and on arm's length basis. If it is within the threshold, then you will require board approval, or A third could be where it is in the ordinary course of business, but not on arm's length basis. If it is within the threshold, you would have to take board approval. Fourth could be not in the ordinary course of business, not on arm's length basis, within the threshold, you would take approval of the board. Fifth could be where it's neither in the ordinary course of business, not on arm's length basis, and exceeds the threshold, you would take shareholders' approval. So you will actually have to see the permutation combination, but suffice it to say that in case of a private company, section 188 is applicable.
I think loan is not covered in section 188.
Sorry?
Loan transactions are not covered in section
No,
188.
loan transactions are not covered under 188. No 188 applicability, since it does not have an audit committee. 177 is not attracted. So it's only a question of disclosure as per the provisions of Schedule 3, and therefore you would have a disclosure. And if disclosure is made, you would report that the company is in compliance.
Okay, so the notes to accounts only. Then.
It will be in the notes to accounts only. And CARO, of course, you will have to cover in CARO also.
CARO is, for this NBFCs, it is not applicable the particular for the 188, 177, and as a NBFC, I think it is exemption in section 186 also. 185,
exempted, and 186, there is a clear exemption. So therefore, it will not come under this. That's correct. 186, there is a clear exemption under 186.11.
Yeah, so that is not covered in CARO also. So as an auditor, anywhere we can report or we supposed to be report, because once AS18 is also silent on this arm's length.
So it will only be in the notes to accounts.
Notes to accounts is just a disclosure only. Then there's no separate report.
Yes, that's right.
Thanks, ma'am.
I would request the questions to be raised by unmuting yourself, because I'm unable to read the questions and also answer. So I'm happy to be taking the questions. If you just. Or if somebody could just read out the questions which are put in the chat, please.
Yeah, ma'am, I'll do that. The last question is, please suggest valuation and CARO relation for the audit to be done in 21-22.
So actually, valuation as such, you don't require any separate valuation. I would in fact say that for the purpose of income tax, if transfer pricing requirements are applicable, you could get that. Or, what you need to see is it is not necessary to have valuation in every case. However, if it is one where you do not have any cup method which can be used, only then you would be looking at it. But valuation, I would say, is not typically required unless it's, let's say, for example, if it's, let me give a simple example of a property which has been given on lease. You would ask for 2-3 quotes from brokers. That is good enough. Something which will enable you to establish that it has been genuinely done and the price is similar to the price at which the property is available on rent in the similar vicinity. And that's good enough. So valuation per se is not required to substantiate. And where the law requires valuation, it is very specifically mentioned. For arm's length, it's good to get a comparison, but it's not necessary to get specifically valuation reports unless it's a transaction where you're not able to come to any conclusion otherwise. For example, if it's a trademark, okay, for trademark licensing or for sale, you would typically have a valuation report.
Ma'am, next question is, private limited companies distributing almost 80% of profit to directors to reduce tax liability and changing remuneration every year as per the profit available. So is there a non-compliance? So that is a question.
So in case of a private company, 197 is not applicable, which basically means the limits with respect to remuneration are not applicable in case of a private company. So the private company has flexibility. All that is required to be complied with is under section 196. It says the directors must comply with the requirements of Schedule 5 Part A. That is, they should be capable of being appointed as directors on the board of the company. That's all. And as whole-time directors, if at all they are whole-time directors. Now, it's not necessary in case of a private company. They may even be non-whole-time and they may be getting remuneration. You also, of course, would be seeing as to whether it is shown as salary or otherwise. Assuming it is shown as salary, you can even show it as commission, but whether assuming it is shown as salary and they are shown as whole-time directors, even then the only compliance required is of 196 to see whether they are competent to be appointed. 197 limits are not applicable. So there is no bar whatsoever on paying this remuneration.
Next question, both income and expenses are covered under related party transactions, question mark. Items like salary, rent, professional fees, etc. paid to relatives are covered under related party transactions. Compliance needs to be reported in the register. Parekh, I think the question list seems to be a little incomplete, but I think you have guessed it right.
Fine. So all transactions, whether they come under the income, expenditure, loss sheet, whether it's a balance sheet item, P&L item, will be treated as related party transaction. What you need to at the beginning of the funnel, see whether the transaction is with a related party. If it is a transaction with a related party, then you need to see whether the company has an audit committee and has the audit committee approved it. Does it require board approval? If yes, has the board approved it? Does it require shareholders approval? If yes, have the shareholders approved it? And lastly, have the disclosures been properly made in the financial statements? Coming back to the question of salary. Now, payment of salary, the contract of employment at the time when you enter into the contract of employment is the stage where you would be seeing as to whether the person's appointment as a related party is approved by the audit committee, board, as the case may be, or shareholders, as the case may be. Once he is appointed, once a relative is appointed, every year for increment, you won't take it to the audit committee. So therefore, salary, that's one part of it. Of course, with respect to salary paid to a related party, there is a disclosure. Disclosure requirement continues year on year, but approval with respect to employment will only be once. So therefore, at the time when the person is appointed, the appointment letter, before issuing the appointment letter, approval of the audit committee would be taken. Disclosure continues year on year. The second question here was rent. Rent, the agreement of rent needs to be approved because that's the one under which rent is paid year on year. So let's say, for example, the property is owned by a private company where the director is a director, and you're entering into a transaction. The company is entering into a transaction with this private company for leasing of space to be used as office premises by the company. At the time when you enter into the leave-in license or lease agreement, as the case may be, initially, you would be getting it approved by the audit committee. Let's assume it's a tenure of 5 years. Then for the entire tenure of 5 years, you would be taking approval of the audit committee. Disclosure, as I said, will continue year on year. Approval to the specific related party transaction will happen only once. It's not one which is covered under omnibus, but it is a specific transaction which will be approved at the beginning of the transaction. You're on mute, Mr. Chintan, you're on mute.
Sorry. Any key highlights for disclosure in case of consolidated financials?
So in case of consolidated financials, the disclosures would continue the same way as in case of standalone. And in case of consolidated, CARO, as I said, there's just para 21, para 3 subpara 21, which will need to be borne in mind, and which basically means all the draft auditors' reports would have to be seen, which in any case is a normal practice with the auditors. You would see the draft auditors' report of all the companies which are being consolidated with the main company, so as to ensure that your CARO report is complete. So for the CFS, you would be seeing this. And only thing is the CARO report has become very, very comprehensive. So you would be actually seeing the CARO report, which has to be a part of the auditor's report only. So that's what I would say. There's nothing new as such.
Next one was, can audit committee approve such transaction which is not at arm's length but beneficial to the company?
Yes, of course.
Yeah, she already responded on that.
Length, it'll then, you have to then see as to whether it's a transaction which falls under 188. Let's assume it's a transaction which is not on arm's length and is not falling under 188, then the audit committee is the only authority who has to approve. If it's a transaction which falls under 188, then it needs to go to the board. And if it crosses the thresholds, then it needs to go to the shareholders also. Now let's assume it's a transaction which is not falling under 188 and is only within the purview of the audit committee to approve. And it's a transaction which is not on arm's length, but in the interest of the company. Now, when would you say it's not an arm's length and in the interest of the company? When the company is paying something more as compared to what is available and maybe typically under cup method, because when you're saying not an arm's length, it basically means you have something to compare it with. And if you're comparing it with something, maybe you would say that the specific quality that you're looking at or consistency or the quantity that you're expecting is not available, and therefore you're approving it, although it's not an arm's length basis. So if it is a question of purchase or sale, it definitely will go to the board also, especially typically if it's purchase, because not an arm's length being sold. Now there's another possibility. Yes, of course you can sell not an arm's length, because you may have manufactured some goods for, let's say, export, and for whatever reason the order is cancelled. There is a short shelf life which is available for you to dispose of the material, and the quantity is one which cannot be split into several customers, and therefore the price cannot be the only determinant. All these factors will be taken into account when the audit committee approves it. Your question also said it is in the interest of the company, which basically is the most important point that needs to be considered. My only point of caution here would be, in the minutes, please ensure this is very clearly brought out. If you otherwise only look at numbers, it may not bring out the other specific issues which need to be considered. Let's say, for example, the goods are in a foreign country and you have a subsidiary in that country or an associate in that country, and bringing the goods back to India may not be in the interest of the company. So therefore, you're then deciding to sell it to that local company and ensure that you don't book a loss. So that's also possible. So those unique situation will therefore need to be clearly minuted.
Ma'am, next question is, are salary increments needed to be approved by audit committee prior to its dispersal?
So, okay, when you're referring to salary increments, if the salary increments are as per the terms of employment in case of a relative of a person who's covered under 188, and if it is as per the terms of employment of the person, as per the remuneration policy, no, you don't require salary increments to be approved. Let's assume directors, when you are going to be increasing their salary on a yearly basis, does it require approval of the audit committee? I would say you need to go by the resolution that has been passed by the shareholders. And if the shareholders in the resolution that is passed with respect to remuneration of salary have very clearly granted authority to, let's say, the board or the nomination and remuneration committee to grant approval up to a particular limit, then the related party provisions will not get attracted, and hence for increments you don't require approval of the audit committee. So you'll need to see the resolution, of course, but if the resolution is silent on who the authority has been granted to, or if the resolution is of a specific amount, then granting any increase will definitely require shareholders' approval, and in which case it will require audit committee, NRC, audit committee, and board, and then shareholders, if no increment has been specified. There are a few companies where they do this. Every year they take approval of the shareholders to increments. But my view is, practically speaking, take an enabling provision when you take approval of the shareholders, and within that provision, the NRC can recommend, board can approve, or NRC itself can be granted the authority to finalize the increment so long as it is within that power.
Yeah, ma'am. Next one is are related party transactions from a private limited company needs compliance like approval of audit committee, shareholders, etc.
So let's assume this is private company which has listed debentures. As I mentioned a little while ago, high value debt listed entities are also required to have audit committees, and hence they will need to comply with all these provisions. Let's assume a simple vanilla private company which is not listed. You don't need an audit committee. There's no question of any compliance. 188, however, is still applicable.
Next is a holding company undertakes project for execution, which is executed by a wholly owned subsidiary on its own or with its UP partner. The terms mention payment to subsidiary post realization of debtors. So I think the question seems to be incomplete. Mr. Vinay, you can post the entire question again. I'll read the next question. Oh, he has posted, sorry. A holding company undertakes project for execution, which is executed by a wholly owned subsidiary on its own or with its partners. The terms mention payment to subsidiary post realization of debtors. However, debtors are due over a year and the subsidiary has requested for an advance against these debtors for a short time period as they have incurred, they have incurred expenses with the partners immediately after the deliverables. The terms are between holding and subsidiary undertaking project of such nature ongoing by bidding in RPF have requisite approval. Can such an advance be made without any additional approval or attracting any CARO provisions?
So first and foremost is if the holding company has submitted a bid and has subcontracted the contract to the subsidiary company, these subsidiary companies, if they are wholly owned subsidiaries, then the transactions would be outside the purview. Let me come to that in a minute. But if the subsidiary companies are not wholly owned subsidiaries, and as per the terms of contract, the holdco is supposed to be paying money to the subsidiary, then if you're getting an advance, that advance, which is something different from the first transaction, will require approval. So just to put it simply, going by your question, holdco has submitted the bid, subsidiary has executed the contract, and the money is supposed to come from the holdco to the subsidiary only after receipt of monies from the debtors, and debtors have not paid. So in order to make up for the working capital crunch, if the holdco is going to be giving an advance, does it require separate approval? Answer is yes, it will require separate approval, unless the first resolution had very clearly covered it, saying that while in the ordinary course, it will be only on payment of receipt of payments from the debtors. In exceptional situations, the holdco may provide financial support of an amount not exceeding XYZ, then it is covered in the earlier approval. Otherwise, if it is not covered in the earlier approval, yes, you will require separate audit committee approval, because whatever is the transaction needs to be approved. The first transaction was for executing the project. The second transaction is for getting the advance. The advance is more like a loan. It will not be it will be shown as advance and not as payment made. And in the alternative, the transaction originally itself could have been so structured that, from time to time, as they may desire, they may give monies, but that is not the way it has been structured. And hence, to answer your question specifically, will it require audit committee approval again? Answer is yes, it will require audit committee approval again.
Yeah, ma'am. The next one is whether quotation from two independent parties is sufficient to justify related party transactions arm's length for a private limited company.
I would say yes, prima facie, it should be okay. Normally, it is 3 quotes which one would take, but
okay.
It's yeah.
If holding and subsidiary companies participating in tender as consortium, will it be required to get approval of board before participation or after award of work?
So here what is important is, are they just coming together? Is it an agreement between the two of them? Is it a transaction between the two of them? Answer is, I would say there would be some role and responsibility which the two of them would be sharing. There would be certain obligations which the two of them would be very clearly providing for in the agreement. Depending on that, yes, it will be treated as a related party transaction. You will need to take approval before you file your bid, because agreement comes into being and execution is later. So before you enter into the agreement, because once you've entered into the agreement, it's a binding agreement where you will have to comply with the obligation which you've already agreed with. So what you can do is have a template of the terms on which you would be entering into agreement, and then subsequently say that, because there will also be a monetary piece that you will be entering into when you're entering into such agreements. I would advise you to take approval beforehand.
One more question. Director has given his personal property for availing, the company has availed the loan on the basis of the security of the property given by the director. Now the director is in need of that property, and if the property is taken back, then the bank will stop the facility, and this will affect the entire business of the company. In such situation, can audit committee approve loan of some amount less than the value of property to such director? It is to save the business of the company.
I'm sorry, loan to director is very clearly
Obviously prohibited. Yeah.
So therefore, there is no question of giving a loan. Now, talking of this property being mortgaged, if the company is able to get money either out of its own sources or out of some other loan, my advice is repay the first loan, take the property out.
Definitely. 100% WAS, sourcing all traded goods under wholesale and retail trade, bracket FEMA, from foreign partner company and payable to parent company remaining unpaid year after year. What disclosures are required for reporting in AFS's audited financial statements, I suppose? That is I assume. Yeah.
So just repeat the question once again. The
Yeah,
parent.
sure. 100% wholly owned subsidiaries sourcing all goods under wholesale and retail trade category from a foreign parent and payable to parent company is remaining unpaid year after year. So what disclosures are required in the audited financial statements?
So basically this would be shown as creditors, and creditors have remained unpaid. Creditors have been overdue because you have purchased from the overseas party, and it is trade receivables, trade payables. In that disclosure, you would be mentioning as to what has been overdue for so long. But what is more important is you have more of FEMA compliances in this case, where you have not made payments, because you get a maximum time period of, I think,
180 days. 180 days.
Yeah. So that's what is more important for you to ensure compliance, because in terms of trade receivables and trade payables, I don't think there's a reference to related party per se. It's only what is good and what has been overdue, which is required to be mentioned. Age analysis is required to be mentioned, especially in terms of trade receivables. This, you're on the other side. You're supposed to be making payment.
I think, ma'am, I think one last question. Even in case of a listed company, the comparable transactions are just managed and remain on paper. Board of directors and management generally manage and get comparable transactions. I think this is more of a comment rather than the question. What precautions auditor must take in case of comparative transaction cost? And sometimes it is too suspicious.
If it is suspicious, don't trust.
Yeah, I think there are no more questions. Krishna ji, you can take it over, please. Krishna ji?
Yes. Yes, Chintan ji.
Yeah. You need to make some announcements. You can do that. I think we are over with the session and the questions also.
Okay. So there is one or two announcement. Sorry. So we had a budget session post budget. Budget is on 1st. So on 3rd, we are having a session on between 4 to 6 p.m. by Sri TP Oswalji, and this session is online only. And after that, on 6th, we are having another session on capital market, on budget, that is on the Sunday in the normal time, 11 to 1, 11 a.m. to 1 p.m. And we are having a live session on budget at Kohinoor on 1st between 11 a.m. to 1 p.m. So those who are interested, so they can come. But the only request, you have to you have to do the online registration in the Google form, which has already been circulated to the members. So these were the announcements. And with regard to today's session, this session, Madam had taken all the practical aspects, and members have been benefited by this session. Now I request Chintan sir to give a formal vote of thanks to the madam. Over to you, Chintan ji.
Thanks, Krishna ji. And the comments are already flowing in the chat box. And Madam is an encyclopedia of corporate laws, a nice session, excellent session. So the vote of thanks is very formality, and definitely would like to do this and honor ma'am, who has been speaking so spontaneously always. It's really a great honor to hear you always, because you are at the spur of the moment. Always all your sections are on tip of the fingers, and it's a wonderful session always to hear you. Ma'am, we thank you for enlightening our members and sharing your knowledge and thoughts on this topic of CARO related to along with the related party. And members, as Madam has already spoken, the CARO is getting stricter and more elaborate year after year, and the CARO 2020, which is becoming operational from the next financial year, we need to be more alert and do our duties diligently under the guidance of what Savithri Madam has already spoken. So thank you, Madam, for this wonderful session. We appreciate your time.
Thank you very much. It's been my pleasure. Thank you very much.
Thank you, ma'am. Now we close the session. Thank you.